I
Think we're
think we
ready
can get
now?
started. Yeah.
All right. Okay.
So welcome everyone. This is our webinar on trademark enforcement and defense strategies. But first, I would like to tell you a little bit about our new small business and inventor hub, which we recently launched. Basically, it's been designed to serve the unique needs of inventors, entrepreneurs, and small businesses. And the way that we're doing that is we're providing free resources and transparent pricing so that these newer businesses, inventors, entrepreneurs, things like that, people who are doing those things can get what they need from our intellectual property attorneys in a bit more of a personalized way. So if you'd like to check that out, please visit our website, dbllawyers.com/hub. That'll quickly take you to the page, or you can click, I think we have a button on our side menu that will take you there as well.
Great. Thanks, Kara.
Mhm.
So this is our webinar on trademark enforcement strategy and other things related to trademark enforcement. I am Tom Dunlap. I'm your speaker today. Kara is our lovely moderator, I guess, or questioner. She's going to ask me questions. I'm going to answer them, and we're going to kind of take it from there. So, Kara, I will let you dig in. I'm a partner at Dunlap Bennett and Ludwig. I'm also a college professor. I teach intellectual property as well, and I teach the Virginia State Bar CLE or Virginia CLE on IP, and have written two books, one called Essentials of Intellectual Property and another one called Intellectual Property Litigation and Tactics. So very exciting books. If you don't have them, they're for sale on the Virginia CLE website. Okay,
You're
Kara,
definitely
I'm
qualified
ready.
to teach. You can teach students, teachers, and your clients.
Well, I have done that. Am I qualified? Am I doing it well? I don't know, but
I think you're doing it well. Let's
I
get into
appreciate it.
general
Okay,
trademark enforcement.
sure.
Um, First, by talking about maybe what are some of the most common types of trademark infringement that businesses are facing.
So usually trademark infringement is literally just some unauthorized use of a brand. I think what most people are familiar with are things like counterfeit goods, fake luxury goods, but sometimes it's inadvertent infringement and sometimes it's intentional infringement. So sometimes people go out of their way to try to pass off their goods like in other companies to get the value of that brand. Because you have to remember that trademark value derives from the owner of that mark attaching that brand, that name to whatever it is they're selling. A couple famous cases probably people have heard of is Chanel, the handbag and other things maker versus the Real Real was a pretty big case. Tiffany versus eBay. And I bring those cases up as good examples of common types of trademark infringement you see because the court reached different results in those two cases. In Chanel versus the Real Real, Chanel sued the Real Real for selling fake Chanel handbags on their website. And in Tiffany versus eBay, Tiffany did the same thing for selling fake Tiffany goods on the eBay platform. But in the Real Real case, the court is unsettled, but it looks like the court is probably going to rule against the Real Real. And in the Tiffany case, Tiffany's probably going to win. And why the different outcomes? Why did Chanel win in the Real Real? Because the Real Real apparently has control over what people put and they review the products before they're posted, whereas eBay is not responsible for the content that it posts as long as it acts quickly to take down alleged fakes. So that's the big difference there. But yeah, most common type of trademark infringement. Counterfeit's really common, but basically it's using a mark that's confusingly similar to a registered trademark in the same goods and services space.
So how can a business monitor its trademarks to make sure that nobody is using it in an unauthorized way or it's being infringed upon?
So I will say the easiest way to do that is to pay a company, or our law firm does it. We do it for some government agencies, we do it for companies. It's not expensive, but it's not inexpensive. It does cost money. If you want to do it yourself, then you have to do a lot of individual things because there are different places where your trademark can be infringed. So you think about all of the milieus or all the locations where trademarks appear and where infringement can happen. So you have online and digital monitoring, which includes websites, social media, domain names, e-commerce platforms, even social media handles. Then you've got market monitoring. So we regularly send cease and desist letters to retail stores, especially on behalf of some of our toy company clients, where products show up that are counterfeit. Trade shows, You can do customs monitoring. You can actually file with US Customs if you have a registered trademark, and they'll sort of monitor for you, not wholly effective. There's also trademark registry monitoring. So if somebody files to register a mark that's similar to yours in a similar space, you want to know about it. That's really hard to do unless every few months you go check the USPTO register and conduct a whole search. Usually easier to have a company do that, but monitoring the USPTO database and the WIPO database are important. And then there's kind of industry specific monitoring, like pharmaceutical companies might monitor the Orange Book or names of drugs. There's also app stores. So your trademark could appear maybe not in social media or anywhere else, but somebody develops an app and uses your trademark name, or somebody puts it on a billboard. So there's a lot of places where your trademark can appear. And I think the easiest solution is to hire a company to do it. But those are the places you can go if you want to do it yourself. And you have to do it fairly regularly because infringement can happen at any time. You could look something up today, and then 2 weeks from now, somebody could start infringing your trademark and you wouldn't know. So
that's a lot of different places you have to look.
There are a lot of places you have to look if you want to do it yourself. Best solution is to use a law firm or a company.
So say that a company, either by doing it themselves or working with a law firm, finds a potential case of infringement. What should they do?
So the first thing to do is take a screenshot if it's on the internet. So document the infringement, whatever it is. If you see the infringement on a billboard or at a store, we have a lot of clients who have buyers and people who will see fake products in the store and take a photo with their iPhone, but they document it. They document the date and time they took the photo. Same with the screenshot. And then honestly talk to your lawyer and say, look, this is the infringement. I believe it's infringing. If it's obvious, then great. But with your lawyer, will come up with a strategy. Typically, it's a cease and desist letter, but you have to be careful. If you send a cease and desist letter, then you can get a defendant, if they're big enough, filing something called declaratory relief or taking action you don't want them to take. So you have to figure out with your lawyer who is the defendant and what kind of cease and desist letter are we going to send them. But that's typically the route it takes. Find the infringement, you document it, capture it so it doesn't go away, so you know it's there, and then you send a cease and desist letter.
So then we're getting into trademark enforcement there. What's the difference between trademark enforcement and trademark protection, just for clarity?
Sure. So trademark enforcement is after you have a trademark, when somebody infringes your trademark and you're trying to stop them from infringing your trademark and you're enforcing a trademark you have. Trademark protection is just the fact that you have a registered trademark, or sometimes people call it trademark prosecution. I think really that's probably the question you're looking for. Trademark prosecution is the process of getting a trademark through the USPTO. And it is an adversarial process. The USPTO issues office actions and you respond to those, and third parties during the process after the mark is published can object to your mark. So I think what we're talking about here for trademark protection is obtaining the trademark, the prosecution process, and then trademark enforcement is post-registration, enforcing that trademark that you own.
Makes sense. So you just mentioned the USPTO. What role are they playing in trademark enforcement, and how is that different from private enforcement?
So the USPTO does zero trademark enforcement per se. Now, what they do, that sounds terrible. What they actually do is when you file a trademark application and you have a registered trademark and somebody else files a different trademark, but it's similar to yours in the same space, they may reject this different trademark because it's similar to yours. They're not enforcing your trademark. They're just using it as a basis to reject this other person's trademark. And that's because their role is different. The USPTO's role in the process of getting a trademark is to make sure the consumers, the consuming public in the United States is protected. And they don't want the consuming public to be confused. And I think I should just touch on this because it plays in, if you know this one sentence, you know everything about trademark enforcement and infringement you need to know. It's from this case called In Re DuPont. And the statement is, when you look at two trademarks or two brands, is there a likelihood of confusion as to the source or origin of goods or services in the relevant marketplace? That's it. Now, I'll break that down a little bit more, but that one sentence is from In Re DuPont. And there are 13 factors, and they weigh heavier or lighter depending on the case. But generally speaking, if you look at two brands and a consumer's like, hey, that's the registered trademark, that's the Louis Vuitton, I'm seeing Louis Vuitton. Is that confusing to me? Might I think that's a Louis Vuitton? Might I think, or it's associated with, or is it tarnishing their brand, something like that? That's likelihood of confusion. Is it so similar, or is it making me think? Kind of a famous case about that was Gucci versus Guess. Gucci claimed that Guess was using the Guess G, like a Gucci G, on their products, intentionally selling Guess items. And I'm sure everybody knows this. Guess I guess it's a good brand. It's a brand, but it's not as expensive as Gucci. And so Gucci claimed they were taking their interlocking Gs, and Guess did the same thing. And they took them to court, and they won $4.7 million. So that's an example of likelihood of confusion and success for Gucci, not a success, a bad market player, bad decision by Guess at the time. So back to what you were saying. So what does the USPTO do? So it does handle protecting consumers. The other thing it does is it has a process called the Trademark Trial and Appeals Board. Now, the USPTO has nothing to do with initiating a Trademark Trial and Appeals Board case. And a Trademark Trial and Appeals Board case involves a third party. It's just a different route than the federal courts for litigation, a different route to attack a trademark owner or to deal with the trademark owner if you feel like they shouldn't have that trademark or something like that. You can file a petition to cancel. Variety of things you can do at the Trademark Trial and Appeals Board. You don't get damages there, but that is a forum that the USPTO manages, but they don't play any role in actual enforcement themselves.
Okay, so when it comes to more private enforcement, like you mentioned before with cease and desist letters, what is the process for sending that kind of letter, and how effective do you think it is?
So we kind of talked about this a little bit before, but gathering evidence, you draft the cease and desist letter. The cease and desist letter contains a comparison of your brand versus the brand you say infringes your brand and why. And sometimes it contains a little bit of case law, like, hey, here's exactly why, even though the marks aren't exactly the same, here's why we think they're likely to be confused. And sometimes they're effective, and sometimes they're ignored. They're effective if you're dealing usually with a bigger player or somebody who's sophisticated or somebody who's hired an IP attorney. If the letter you've sent is good, they'll usually say, okay. Nobody wants to fight a trademark case. And I think this is a really important point. In patent cases, huge damages, potentially attorney's fees. Copyright cases, statutory damages, big damages, automatic attorney's fees under the statute. Trademark, not the case. And while you can get damages for willfulness, it's pretty rare to win a willfulness case, and it's pretty rare to win big damages. So when you hear these numbers like Gucci versus Guess, usually we're not talking about Gucci versus Guess. We're talking about, JoJo's Pizza versus JoJo's Restaurant. And so we're not talking really anything in damages. I mean, there's some damages, but it's usually not worth fighting because you don't generally get your attorney's fees and you don't generally get punitive damages. So sorry, back to the question. So you asked me a process. So process after the cease and desist letter, if it's ineffective, then you've got the option of suing them. If they ignore it, there's really nothing else you can do. Or if it involves something where they filed a competing mark with your mark and you've sent them this letter, you can contest their application at the Trademark Trial and Appeals Board at the USPTO. But generally speaking, you've got to sue them. Now, another weird thing about trademarks, which is not true for patents or copyrights, and not everybody knows this, you can actually file a trademark infringement case under the federal statute in state court, which is crazy, and nobody really does it. And I think there's one case in Virginia, and it's my case from 15 years ago, the Buffalo Wings case. And I had to explain to a judge what concurrent jurisdiction was because we brought a bundle of other claims related to this restaurant. But the point is there is concurrent jurisdiction, and it is possible. And strategically, there might be a time you want to do that. It's pretty rare, and I don't think I've seen a state trademark case in the last 15 or so years since that time, but it's possible.
So how do you decide when to escalate to litigation instead of just settling outside of court or giving up?
So it's cost benefit analysis. Typically, when you've sent the cease and desist letter, if the other side says, mea culpa, I'm not going to infringe on your trademark anymore, usually you enter into negotiation of a sell-off period or a transition period. So if it's something like a company that sells shoes and your client sells shoes, you can say, look, you can sell off the inventory you have for the next 60 days, but you've got to put a notice out, take it off your website right away, stop using it, stop doing AdWords. And usually there's no damages, usually no money exchanges hands. Here's a weird thing about trademark settlements. Often, if we have a bigger client and we send a cease and desist letter to a little company's like, oh my God, if I have to change, it will cost me, $5,000. And the bigger company's kind of like, that's really nothing. That is way, way less than it would cost for us just to get a lawsuit filed. So we'll give you 2 months and $5,000, even though you're the one infringing, to change your brand. And I know it sounds weird, but that happens a lot in trademark cases because there aren't those statutory damages and there aren't those attorney's fees that are typically awarded in copyright and patent cases.
That's really interesting. So I'm assuming there's different ways, like different results that you can seek if you go to litigation. What are the differences between seeking damages, injunctions, or other potential results that you can try to get?
Okay, so damages, there's really just two things. There's damages and injunctive relief. And injunctive relief is a whole host of things. Injunctive relief is stop using the trademark. Injunctive relief is destroy the infringing goods. Injunctive relief is anything in that vein that involves somebody having to do something. Damages is money. So those are the two things. Typically, damages are lost profits, for example. Again, very hard to prove. You have to prove this other person's use of the mark cost you money. Now, if it's Gucci versus Guess, you can find out how many purses or whatever it was that Guess was selling and say, well, those are my lost profits. Whatever the profits they made on that, that's mine. But if it's, two small family-owned restaurants or even regional companies, it's a little bit harder to calculate lost profits. Injunctions are typically the primary remedy and reason. You want that other company to stop diluting your brand and to stop using your brand. And if there's tarnishment, so tarnishment, real quick, just this concept, because a famous case happened in June of this year on tarnishment. It was Jack Daniels versus, can't remember the name of the company, Jack Daniels versus a dog chew toy company. And the dog chew toy company had made a Jack Daniels bottle called Old Number 2, which is a play on Jack Daniels Old Number 7. And the Old Number 2 is a squeaky toy, and it said Old Number 2 on your bedroom floor or something like that, referring to poop, dog poop, right? But Jack Daniels is like, you're tarnishing our brand. You're diluting Jack Daniels. And yes, people know that that is not a bottle of whiskey and it's a dog chew toy. So they sued them in the Ninth Circuit in California. And the Ninth Circuit in California said, you know what? Jack Daniels is right. Brand's being tarnished. And your First Amendment right to parody or free speech under something called the Rogers test doesn't protect you. Then the Pooh Chew Toy Company, whatever the dog chew toy company is called, they appealed that to the Ninth Circuit, which is where California is. And the Ninth Circuit reversed and said, free speech, you can do it. It was parody. That was appealed to the Supreme Court. This is years later, June of 2024, I think it was this year. The Supreme Court came out and said, we agree with the district court. Parody does not extend that far. And the main thing was that this chew toy company was getting commercial value out of the Jack Daniels bottle. And it was really the fact that it was a Jack Daniels branded looking bottle, even though it didn't say Old Number 7 or whiskey, it said Old Number 2, but they were deriving commercial value. So it basically said that the Rogers test, the right to parody or make fun of, doesn't extend that far in the commercial space when you're making money off of the parody. You don't get that protection. So I think I went a little bit afar of what you were talking about, but I did want to talk about tarnishment because we didn't really mention that as a type of infringement issue. It does happen. It happens again. You have to be a bigger brand for something to be tarnished. But yeah, so that's the summary of the kind of remedies: damages or injunctions.
That's really interesting about tarnishment. And I think since that's a relatively new decision, that might have more impacts going forwards. So thinking about that dog chew toy company, if your company is being accused of trademark infringement, what steps should you take?
The absolute only step you should take if you're accused of trademark infringement is to call your lawyer, because it might not be true. I mean, you get trademark. Adidas will hit anything with 3 stripes going slightly sideways with a cease and desist letter. And we have been successful. Usually we negotiate with Adidas because they'll sue your pants off. And they're kind of famous. They had the case against Tom's, which they lost. But they win a lot of cases by spending a lot of money, and they're aggressive enforcers of their trademark, which is fine. But you might not be infringing and you might not have to give up all your trademark rights. And you do want to negotiate with that company. You don't want to just throw your hands up and say, yeah, here's usually these cease and desist letters when we send them or when we get them for our clients. They say, give me all of your sales information, how much money you've made, and stop using the trademark right away. So most companies aren't going to just send that stuff to the other side. Most companies are going to go see their lawyer, but that's that's really, those are the steps you should take.
So what else would a company do if they believe that their mark is distinct for sure?
So if they think it's distinct, the first thing you
Mhm.
do is respond to the other company. You don't want to end up in litigation, even if you think it's distinct. You could file declaratory relief. Um, Usually it doesn't happen. Strategic reasons, your lawyer may decide that's a good decision, but that's a big decision. Usually you just do some detailed research on the mark, on the marketplace, what the goods and services are, and see if it meets that DuPont test. Is there a reasonable likelihood of confusion in the relevant marketplace? If I'm selling chew toys and somebody else is selling whiskey, is that the relevant marketplace? I mean, it could be if it's a famous brand like Jack Daniels, but if my company's like Tom's Whiskey and it's Tom's Chew Toys, that's not really famous, at least not in those spaces, maybe in law. So you got to talk to your lawyer. I mean, that's
So
the short of the story. Every case is going to be different. Yep.
what are some of the common defenses that people use in these trademark infringement cases?
So you can say that I mean, a common defense is if you were using your mark first, even though another company has a registered mark, you might have concurrent use rights. You might have rights in the geographic region where you've been using it for 20 years and they got their trademark 10 years ago. So that's one argument. You may argue that if your restaurant is a restaurant called Sunshine in California and a company in New York has Sunshine for their restaurant and they're based solely in New York, they really shouldn't have a trademark because it has to be in interstate commerce. But you could argue there's no confusion because there's no chance that a consumer is going to walk into your very little chance. That's not a great argument in that particular example. But different market sectors. You could say, well, I am selling computer peripherals and this company solely sells software to the government. And even though we have a similar name, it's not exactly the same. You're just basically arguing that your mark is distinctive, usually. But there are other things like concurrent use and things that can come into play depending on the circumstances. But generally, you're arguing your mark is different for some reason. Either the goods or services are different, or the consumers that you're selling to are different, or that the mark itself is different. Usually a combination of all of those things to some degree.
Are arguments such as fair use or abandonment commonly used in trademark cases?
Not commonly. I mean, abandonment can happen, and abandonment's pretty rare. It's usually not argued because somebody's abandoned their mark. So a more common argument might be genericide. I think that's kind of a fun one. So it can be argued that if you don't enforce your mark and people start using your trademark as the word for something, like I'm going to Google it is a good example, and Google's worried about this. It can become generic. Some examples: aspirin was a trademark at one time. Escalator was a trademark. Escalator is something like moving stairs in Latin, and the Otis Elevator Company trademarked it. And then they let everybody use it because they were like, this is great marketing. Everybody's calling their moving stairs escalators too. And there was a big case, I think, in 1950. And lo and behold, now every moving stairs in the world are called escalators because the Otis Company gave up their trademark through genericide. So that's kind of abandonment. Abandonment really is just complete non-use of the mark. Genericide's more common. If there's complete non-use, usually nobody's defending it. And you can, if somebody stops using a mark, typically, legally, it falls under an equitable doctrine called laches. And laches is in trademark world is 3 to 7 years. So it depends on what the non-use is and what the character is. But you can stop using your mark for a year or two and go back to it. And you don't have an abandonment issue as a trademark owner. But if it's 7 years, you definitely do. And if it's somewhere in the middle, it's a facts and circumstances question. Fair use, we just talked about Jack Daniels. That's what Jack Daniels argued. They argued fair use, parody, free speech, and they lost. And there's a test called the Rogers test that comes into play for that. But the Supreme Court really narrowed that a couple months ago in June.
So it sounds like, from what you've said a few times, that one of the main claims in these cases is likelihood of confusion. So how can a company prepare for and defend against those kinds of claims?
You can't really prepare for the claim if you're aware that there's a likelihood of confusion with another trademark right now as a company and you're using that mark and you don't have a registration. That's not a good business decision. So you either need to find a different trademark or you need to find a different trademark. You can't really prepare for, I mean, if you're aware of the infringement, don't infringe. That's my first
Right.
piece of advice. Come up with a
You
different
can
brand.
prepare by being more creative.
You can prepare by being more creative or aware. I will just say this: the best way to prepare for trademark infringement is make sure that you have a trademark, that you have a registration. If you do that, then you have gone through the process with the USPTO and they've cleared it. Other parties have had a chance to oppose. If you get a registration, it's going to be really hard for someone to challenge the use of the brand that you have. So register your trademark. That's the absolute best advice you can give a business. Getting a trademark search done is fine, but then 2 weeks from now, somebody could register your trademark and they might have rights that
Andrew,
exceed yours because they get a
I
registration.
seem to have misplaced my
Uh-oh.
notes.
Sorry, let me mute this person. Oh, I can't. Thank you, Ayla.
Okay.
So what happens? Obviously, they need to register. What happens if they get a trademark opposition during the registration process?
So usually the first thing that happens with an opposition is not an actual opposition, it's a request to extend time. So I usually get a polite call from the other lawyer that says, hey, we're going to go ahead and file a request to extend time. The USPTO pretty much automatically grants those. And then you enter into a conversation with the other party that plans to file an opposition. And that's usually happens when they're experienced trademark counsel on both sides. Sometimes you will get somebody just filing an opposition without requesting to extend and trying to negotiate, and various reasons why. But then you enter into an adversarial process that is between the two parties. An opposition is coming from another party that owns a mark, and the USPTO has said, I think this mark is fine. I see no conflict in the USPTO registry. Remember, the USPTO doesn't check common law. They're checking the registry. They don't want any conflicts on their huge USPTO registry. But somebody can say, I think the USPTO is wrong and they didn't consider my trademark the right way. I'm going to oppose the registration of your mark. And then you enter into a process between the two parties managed by the USPTO and an administrative law judge as to whether or not your trademark is registrable. So no damages, but it is a significant adversarial process in some cases. In some cases, it's not. In some cases, it's a couple briefs. So
far we've mostly been talking about the US, but what are some of the challenges in enforcing trademarks across multiple countries?
So trademarks are territorial, and super important to remember that if you have a US trademark, all you have is a US trademark in the United States. You have no rights in Canada, you have no rights in the UK, even though they all speak English. So somebody could see your amazing brand, your clothing company, and they could set up shop in the UK tomorrow, file a trademark registration, and then they own your brand in the UK, even if you've made it famous in the States. So first piece of advice is if you think there's any value in another market or you're worried about that, is to file for a trademark registration in every country that you're worried about it. Now, there is a way to do that in a consolidated way through WIPO. And I think there are now like 195 countries that are members. They keep adding countries. WIPO administers national trademarks through a central receiving location, usually Geneva, Switzerland. So you file a WIPO application. Because the US has signed the treaty, we automatically have rights to then designate any of those 195 countries. Now, people are like, I want an international trademark. No such thing. You get a national trademark in each country. And when you go to WIPO and you designate each country you want to file in, it's great. There's one filing fee to get into WIPO, but each country charges their own filing fee. And then WIPO is like, it goes through an international phase where WIPO examines it very briefly, and then they hand it off to each country. So you could file through WIPO and the UK could grant your trademark, but the EU might not, or China might not, or Mexico might not. And you might not elect to file in Kazakhstan because for some reason their filing fee is like $1,600 more. Whereas China's fee and Mexico's fee is about $450 to add those countries. I don't know, the fees don't make a whole lot of sense as to why different countries charge different things, but you have to have a trademark in each country. Huge risk if you don't. And then once you do have a trademark in each country, enforcement is also national. So there's no such thing as now usually we coordinate international enforcement of trademarks for all of our clients. Huge example, during COVID, the CDC logo and the certification marks for filters on masks. We coordinated the filings of all of those. So we're attorneys for NIH, and NIH controls the trademarks and brands of the CDC. And that included all of these certification marks for mask filters, the N95 and the N99 masks. and there were counterfeits popping up everywhere with these certifications on them, not just in the US, but in other countries. And of course, our government being beneficent was worried about that. So we worked with our client in that case to enforce not just in the US, but in every other country. And that usually involves finding a local attorney in that country, which we have one pretty much everywhere, and coordinating with that local attorney to take enforcement actions. In most first world countries, it's pretty much like the US, but it does vary by region. So.
And so you're being humble. You didn't mention that you won an award for that.
Yeah.
From the government.
Yeah. So no, our firm did good work. It was a interesting time. A lot of work.
So it sounds like because you ideally need to file in multiple countries and you don't have any rights if you haven't, how can a company deal with a situation where somebody squats on their trademark or possibly is counterfeiting in a foreign market where they weren't previously registered?
So if the question is you're not registered in that foreign market and somebody's using your trademark there, if they have not registered that trademark that they're using there, you should go register there. Absolutely. Or depending on the country, if you were selling in that country beforehand, even if they have registered, and we just had a case like this for a big client of ours, a company based in Turkey started filing trademark registrations in the UK of our clients' trademarks and selling our clients' products in the UK, like counterfeits of our clients' products. Like these aren't like a t-shirt. These were games, like board games. Like the entire thing was copied, even with our client's brand on it. So what you can do in that case is, since our client was already in the UK but had no registrations for each of these games, is you can file a petition to have the trademarks canceled. And so that there are cases, it just depends. Best advice is if you had registered the trademarks ahead of time, you wouldn't have had to do that. And if you haven't been selling in that country before the trademarks are registered, you're kind of out of luck. That squatter or thief then owns your trademarks there. Now, if they're squatting on a domain, that's different, because usually the registrar for a domain, if it's a .com, it's in the US, and you can stop that. And there's a cyber squatting act that you can use to do that.
Okay, so pretty much if you haven't registered, you should have registered.
Yes, pretty much if you haven't registered your trademark, registering your trademark gives the world notice that you own it. It protects you from somebody else sending you a cease and desist generally, because you automatically have done a search. The USPTO's looked at your mark and people have had a chance to oppose it. So you're kind of protected from that. And it protects somebody from coming along and using your mark at a later time and you not being aware of it. So you do have a duty to police and monitor your mark, because if you don't, you could lose rights to it. But it's definitely worth registering your mark. That solves like 85% of any trademark problem you could have.
One more question about international, and then we can move on. Is
Sure.
there a difference in how we are enforcing or strategizing our monitoring across these different legal systems?
There are some countries that are not part of WIPO. So if we're talking about registration, particularly in the Middle East, some of those countries require things like filing with the religious authority in that country and having the religious authority approve the mark and then having it published. For the most part, the strategies are pretty similar country to country, but some countries it's harder to enforce, depending on what the rule of law is like in that country. So this is a kind of a more political question, a bigger question, like how effective is the rule of law and how good are they at enforcing intellectual property in their country through the court systems? And is it worth it to you? But generally speaking, if you have a registration and you have a local lawyer in that country, you're going to have a pretty good, you have a good chance, or you're going to have generally pretty good results if you're willing to go forward with it. So those are the main things.
All right, so now we can move on to our best practices for trademark enforcement. What would you say are the best practices for creating and maintaining a strong program for trademark enforcement?
So first thing you need to do is have registrations. The second thing you need to do is docket those registrations for maintenance. And again, if you're using like our firm, we do that for all of our clients. And the third thing you need to do is have what we talked about earlier, is a monitoring program. You can do it yourself. We talked about why that's kind of hard and how many places you have to monitor. Or you could have a firm do it. And for example, how we do it. If you sign up with us and you want to do trademark monitoring, we send you a report usually quarterly. Some clients, we send it to them weekly. Some of our bigger clients pay for weekly monitoring, and they have a list of marks. Some clients have 20 marks in that list. And we will do a weekly registry search. We'll do a weekly common law search, all in one report. And we will tell the clients if there are hits and things they need to worry about. And the client will look at it and decide, I'm not worried about that. I am worried about that. I need you to send a cease and desist letter. And that's pretty much what a trademark enforcement program, a really effective one, looks like that. If you're a smaller business, you don't need weekly monitoring. The organizations and frankly, the government is doing weekly monitoring, and it's expensive. But I think quarterly monitoring is going to be plenty for you, because if you monitor in January and then we do it again in April, you're just going to see all of the infringement that happened in that time period, but you haven't really lost a ton. And if you incidentally run across something in the marketplace, like sometimes, like I said, for some of our companies, our clients will send us photographs of things they find in stores that are infringing. That's part of your process too, is going to retail stores. So I guess part of it depends on where you're selling or where you're servicing clients and where your trademark might appear. If you're in retail stores, you have to add to this enforcement process that's mostly online when companies do it, a process of actually going to retail stores.
So on the business side of things, is there anything that companies can do proactively to protect their trademarks from dilution or genericide?
Monitor and enforce. And so genericide, we talked about that a second ago. If somebody starts using your trademark to refer to a process like, oh, I'm going to take an aspirin, or Zipper. Zipper was a trademark at one point, but then the company that owned, I don't remember what the company was, but all of these companies let their competitors and other people, Thermos, I'm pretty sure Thermos was a trademark, and there's a Thermos company still to this day, but you can use the word Thermos and be another company. Yo-Yo, a company called Dunkin', I think, owned the trademark for yo-yo, and it genericided when everybody started selling yo-yos. It just became a thing. So some pretty big companies have made this mistake. I mean, the Otis Elevator Company is a huge one. I know it was the 50s or the 40s when it first happened, and the 50s when they lost it, but still. I mean, so that's avoid genericide by that. I think it's really interesting. We
that
don't
Photoshop
make
tries to promote. Sorry, Tom.
Yeah,
Sorry,
so
Tom.
you're way too young for this. But when we made photocopies like 20 years ago, people would say, I'll Xerox that. And the Xerox company went out of their way like crazy to create the word photocopy and make sure everybody is saying, use your Xerox to photocopy something. You are not Xeroxing it. But that was a word. I don't know if you've even heard that word because of your age, but that's something that people said.
I have heard that. I've also heard it in reference to how Photoshop's trying to prevent people from saying, I Photoshopped it.
Yes, that's Photoshop faces that same challenge, and so does Google. So those are at risk of genericide.
So what is the role of trademark licensing agreements in enforcing rights and preventing people from using them in an unauthorized way?
So a trademark license, sometimes when somebody's infringing your mark and you're okay with it, they can pay you a royalty to use your mark. So maybe you are a company that sells some kind of product in like, I don't know, you sell a food, a soup product, and you have a trademark around some mushroom head or something like that, mushroom head soup, and somebody else sells mushroom head mushrooms. And there's no mushrooms in your soup, but you own the mushroom head soup brand. You may license this other company so that you're not committing genericide. You're not giving them a naked license. They have to pay you a fee every year. So you have to be careful. You can't license something to somebody with no restrictions and no fees, because then you've given them a naked license, which is essentially like ignoring the infringement. But if you want to allow somebody to continue to infringe, you can license them the right to use the trademark. I mean, then you're not allowing them to continue to infringe. You're licensing them and they're paying you money. And often you'll see license agreements so if I'm a toy company and I manufacture toys, I might have 5 distributors. I'll license the right to these distributors to sell my trademarked products. I mean, that's a trademark license is part of that, for example.
So how can companies manage these kinds of agreements with other businesses using similar trademarks? Or
How can they?
sorry, how can they manage a coexistence agreement? So like if they decide
Yeah,
that they're in different markets, so they're not technically infringing,
gotcha.
but just to
You're
make
asking
sure
about
like it
coexistence.
continues to stay that way.
I gotcha. So a coexistence agreement uh, is something a little bit different than it's kind of like a license, but a coexistence agreement basically says, I've got my trademark, you've got yours. We either had a dispute or the US, or we might have a dispute and the USPTO might have a problem with it. So let's enter into an agreement between the two of us that says neither of us are going to sue each other. And we're going to take the following steps. Like each of our websites are going to say we're not affiliated and we're going to coexist. So you're a wine. This is a common example. You are a vineyard in California with a trademark for Sunny Wine Company, and I am a distillery in Illinois called Sunny Distillery. And we don't really have the same consumers, but I 100% my distillery. I've been using it, and you have the trademark. I want to keep using that brand. I've been around for 10 years in Chicago. I like making my whiskey. And you say, you know what? Let's enter into a coexistence agreement. My consumers aren't going to confuse your whiskey with me, even though you absolutely are in the same consumer market, the same kind of products, alcoholic beverages,
Sure.
same exact services, your goods at the USPTO. So that's a good example of when a coexistence agreement comes into effect. And usually there'll be things around that, like you're not going to advertise in California. You won't open a branch here, for example, of your whiskey distillery. You will use your design mark that's completely different from ours on every bottle you print so the consumers aren't confused. So coexistence agreements can't just be an agreement. Hey, we're both Sunny. We're just going to both use the word, and consumers won't be confused, even though we both sell wine, because the USPTO would have a problem with that. They wouldn't let you register the mark. Now, you could coexist, but that distillery could never get that mark registered. But with the coexistence agreement, with that many differences, and you include a design mark, maybe they could.
All right, so let's move on to monitoring and policing. Tom, how can
Okay.
businesses use online tools and resources to monitor for these infringements? I think you talked about this a little bit at the beginning,
Did
but I'd
talk
just
about
like
this.
to wrap it up with that.
Okay, I will beat a dead horse. So you can, in addition to hiring our firm, you can use Core Search, you can use Mark Monitor, you can use WIPO's global brand database yourself. You can go to the USPTO and do your own searches. You can use Google. I mean, there's a lot of ways to do it, but you don't have anyone analyzing the results. So you may get search results, and they may have some AI giving you advice, and AI hallucinations. But my opinion, and maybe it's biased, but it's better to have an attorney. Now, maybe you pay for a search service and then you just pay the attorneys to review the searches. That would be something to do. Or you have in-house counsel that reviews the searches, but you should have somebody reviewing the searches who kind of knows what they're looking at. But yeah, those are the ways to do it. Pay a service. Honestly, it's very hard, time consuming, and not worth your business effort unless you're a trademark business to do trademark stuff. I always say that everything in business, you should not be your own lawyer. You should not be your own accountant, your own HR, your own finance person. You should do what your business is. And that is also true with trademarks.
Great. So it sounds like the easiest thing to do is work with a lawyer.
Yeah. Work with
Also,
a
one more
professional.
time, Tom, if
Yeah.
your trademark is being used in a fraudulent activity or a counterfeiting situation, what's the first thing they should do?
Well, call their lawyer. So I did leave out, you can report Amazon and eBay and other online sellers have a program that you can do yourself. They have a takedown program. So if you have a registered trademark, usually you can't even list without a registered trademark anymore. We get daily confirmation requests from Amazon for registered trademark owners that we manage. But you can do takedowns yourself on e-platform sellers. But anything else, you should really talk to your attorney.
Great, thank you. All right, we can open up the floor now for questions if anyone has some questions.
It's a cacophony of silence.
I have
I think I have a question. I'm not sure exactly how to ask it. Maybe it's just to talk a little bit more about it, but I think it has to do with the genericide thing. So if you get a trademark approved, I would assume that they kind of consider how generic the term is before they give you the approval.
Yes.
So if you have a trademark and it's been through the approval process, but later on you see a bunch of uses of it. Say it's your company name that's getting used, but it's like a department name internal to a company. So they're really not using it external, but it's such a generic thing. They call their department your company name. I'm just kind of curious, like, can you talk a little bit more about that? Or, how do you, can something be deemed too generic, but you got it approved anyway? So just something around that.
Well, so if you have a mark that is generic or descriptive, the USPTO will give you a 2E refusal. That means they will literally reject it. Now, so you won't have that trademark in the first place if it's truly generic at the time you file it. Genericide is where you take a unique brand. Escalator was not a word in the English language. The Otis Elevator Company is like, esca means stairs, and I forget what the words mean, but they took two Latin words, combined them, and created that word. So literally fanciful brand. It's a great brand. But then later on, after they got their trademark, like, yeah, go ahead and call your moving stairs escalators, because that's our brand. That's great for us for marketing. That's genericide. Generic or descriptive is a refusal basis at the USPTO. So if I filed a trademark for the law firm, USPTO is going to say, okay, if you're selling apples, you can call yourself the law firm, because that's not generic or descriptive of what you're doing. But if you're a law firm, you can't call yourself the law firm, because what we would be saying to the rest of the world is nobody could ever say they're a law firm anymore because you own that trademark. So that's a generic or descriptive issue. Now, if you convince the USPTO, US News and World Report did this. If you say, hey, US News and World Report is not wholly generic or descriptive, and we're really well known, there's two things there. First, you can go on what's called the supplemental register when you file your application. So you'll file for the principal register. The USPTO will say, it's descriptive. It's not generic, not wholly generic. It's not the law firm, but it's descriptive of what you do. We're not going to give you a principal registry trademark. But you can go on the supplemental, and you still get to put the little circle R next to your name after it's registered. And if you sit on that supplemental register for 5 years, and you can prove, or if you already have this use, you don't have to go in the supplemental. You can make something called a 2F argument. Getting pretty technical. But if you have proof that your brand is not wholly descriptive, and consumers associate those words, US News and World Report, with you, your company, and what you do, then you can get a registration. Genericide's the opposite. It's where you've let it go away. This is the opposite. It's taking a generic brand, or not a generic brand, a descriptive brand. You can never register a generic mark. Let's get out that. You can't be, I'm the Apple company and I sell apples. You can't do that. You can be the Apple company and sell computers, because somebody does that. But you can never get a generic mark. But if it's descriptive, you can get a trademark for that ultimately, if you kind of follow the right path. And you attain, it's called secondary meaning. And I'm not going to dive into what secondary meaning is right now, unless somebody wants me to, but you have to achieve that.
Okay. And
Does that answer your question?
Yeah, thank you. I've got one more. And I guess it has to do, I think you touched on it whenever you were talking a little bit about international, but it applies domestically. So just talk a little bit more about how you could lose your rights to the trademark if you don't defend it. Like what obligations do you have? Is it based on a time period? I mean, let's say that over a period of time, you've seen about 5 different possible infringements, and then something comes up and you finally decide to pursue one of them, but you didn't pursue 5 others. I mean, does that look bad? And does it, assist, do you lose a case because you've neglected to defend it when you should have been? Just talk a little bit more about that, if you don't mind.
You can, and it's a very facts and circumstances intensive inquiry. So if you had 5 other infringers and they were like, it was a domain name handle and they weren't really selling anything, or somebody not directly in your marketplace and they did it for 6 months, and a year into this, you're like, but this one is really competing with my business, and you enforce against them, probably not an issue that you didn't enforce against all those tiny little ones. But if there's a huge infringer out there, so you have your brand and all of a sudden, Apple or Amazon starts using your brand to sell a product, and you have a registered trademark and you ignore it, for a year, any other infringer, including Apple or Amazon, is going to say, you ignored this for a year and everybody knew about this. It was on TV, it was famous, it was, whatever it was. So it's going to be facts and circumstances. The doctrine behind this is a laches doctrine. So legally, it's really equitable. So the question is going to be one of equity. Did you sit on your hands such that you should lose your rights? So it's just, again, it's going to vary on who these infringers are and how long you sat on your hands and how aware of it you should have been.
Awesome. Thank you.
Yep.
Are there any other questions?
I think we killed the lunch hour, Kara,
Great.
so.
All right, yeah, we are nearing the end of the hour. So thank you everyone for coming. Oh, do we have Jennifer, do you have a question?
Oh, I was just going to say thank you.
Okay.
Oh, yeah.
Thank you all for coming. Very appreciated.